Hello, I'd like to welcome everyone to our book talk, The Green Amendment, The People's Fight for a Clean, Safe, and Healthy Environment, with author and PACE alumna Maya Van Rossum in conversation with Professor Nick Robinson. I'd like to start by thanking our wonderful Rachel Silva, Assistant Dean for External Affairs. She has been the moving force behind this event, and we appreciate all of her work. This event is being hosted as part of Pace University's Social Justice Week. So when I think about the work of our speakers, their extraordinary and tireless efforts to define, recognize, elevate, and implement environmental rights, I can't help but think of spiders. Not just any spiders, but orb weavers, which, as you may know, are beautiful spiders that construct massive, intricate webs using delicate, transparent silk that looks ephemeral, but is pound for pound stronger than steel. For decades, Maya and Nick have been spinning silk in the form of books and papers, legal actions, soft law declarations, building communities of scholars and advocates to elevate environmental rights. Today, we can see this profoundly intricate, beautiful, and strong web of environmental rights becoming visible around the world. Maya, in the United States, is considered the mother of the Green Amendment. She developed the term, which is described so powerfully in the book she'll discuss with us today. She is the leader, through her nonprofit, For the Generations, of a national movement to persuade states in the United States to amend their constitutions to recognize a Green Amendment and right to the environment. She was the lead petitioner in the landmark case Robinson Township versus Pennsylvania, which breathed new life into Pennsylvania's Environmental Rights Amendment. And she does all of this on the side. She has served for 30 years as the Delaware Riverkeeper. Maya will be joined in conversation about her book by my colleague, Nick Robinson, University Professor for the Environment at the Elisabeth Haub School of Law at Pace University. Nick has directed his formidable academic talents and career to building the field of environmental law, and most especially nurturing and encouraging the development of environmental rights. He has twice served as chair of the Commission on Environmental Law of the IUCN, founded the IUCN Academy of Environmental Law, and has participated in every major environmental conference since they began in 1972 with the UN Stockholm Conference on the Environment. It's through Nick's nudges and support that I became involved in New York's successful effort to amend our state constitution to add a right to clean air, clean water, and a healthful environment. And I know he's inspired countless other environmental advocates. So looking out at you, we are tonight a group of orb weavers. I see in the audience Tony Oposa, whose landmark lawsuit, Miners Oposa versus Factoran, prompted judicial recognition of intergenerational responsibility for environmental rights by the Supreme Court of the Philippines. I see Justice Nambitha Damusa, Judge of Appeal on the Supreme Court of Appeal of South Africa, which can boast as having one of the most robust expressions of environmental rights in its constitution. And Justice Brian Preston, Chief Judge of the Land and Environment Court in New South Wales. I was planning to talk about his decision in Gloucester Resources Limited, upholding the denial of approvals for the Rocky Hill Coal Project, but in short conversation before this event, he's informed me of two further decisions that are even more sweeping, issuing recently a mandamus to the Environment Agency in Australia to develop a plan for mitigating emissions. And of course, Professor James May, one of the leading scholars in the world on environmental rights. So I'm confident with all these orb weavers in the room, we will also inspire even more orb weavers to help join us as we further support the development of environmental rights. So I very much look forward to our conversation. Welcome.
Well, thank you for that very eloquent and wonderful introduction. It's appropriate, I think, that you chose one of our kindred spirits, the spider, to illuminate the discussion, because if you notice in the Green Amendment, the dedication is to the rivers, the plants, and the animals, and who will be their voice. And I want to make a point of saying that we are sitting today in Lenapehoking, the land of the Lenape, their ancestral lands in which they have this relationship with all creatures, large and small, all other peoples, but also with the mountains and the rivers and nature as a whole. And we have much to learn from the Lenape. And the territory of the Lenape runs through the Delaware watershed, which is where our guest of honor this evening has her Delaware waterkeeper's hat and has done extraordinary work to build the resilience and safeguard the integrity of all living things in the Delaware watershed. And also it extends down to Widener and the work of Jimmy May. So we're all within Lenapehoking. But why do we need a green amendment? I know this is a redundant question, but let's start with the biggest one.
Okay, well, first off, it really is an honor to be here and amongst so many wonderful, wonderful caretakers of the earth and our environment. So thank you so much, everybody, for doing me the honor of sharing your presence and for your amazing work. And I do want to recognize that Professor Robinson, Nick, was my mentor when I was in law school. And I am sure that I would not be here in this moment, having written this book or doing the work that I do, but for his mentorship and his support and all he has done for me. So the reason why I think that we need a constitutional green amendment in every state constitution across the United States of America and ultimately at the federal level, because the way our US system of laws was written and the way it is has been increasingly implemented over time is it's really focused on legalizing environmental pollution and degradation through reviews and permits. It's not really focused on preventing harm in the first place. Every law is written that way. In fact, if you look at the Clean Water Act, right, whenever I raise in my advocacy as the Delaware Riverkeeper, the point that when the Clean Water Act was first written, it included a goal of preventing pollution discharges to our waterways, zero pollution discharges to our waterways in the United States by 1985. If you point that out to government officials or to representatives of industry, they guffaw, they laugh, they nod you off, they say that's ridiculous. Right, but that really was a genuine goal of the Clean Water Act at the time, even despite the fact that the Clean Water Act was, like all the other laws, written to say, well, you're entitled to pollute and to degrade the environment as long as you have the right permit from the right agency in order to do so. And that laudable goal of prevention of harm just got lost in the annals of history. And over time, increasingly, the Clean Water Act and all laws have just been focused on this idea of we will manage pollution and degradation. We will not focus on prevention of harm. So as a result, and because the laws are written that way, there's not really anything people can do when that permit gets issued that allows that industrial operation that's going to desecrate our waterways, our environments, our communities, that advances environmental sacrifice zones and continues to sacrifice communities of color and indigenous communities and low-income communities to more and more pollution and environmental degradation. Because the laws allow it, there's not really anything that people can do here in the United States of America except plead and cajole and perhaps protest, but ultimately sit down and accept it because the law allows it. There is no higher power. There is no right of the people to pure water, clean air, a stable climate, and healthy environments that they can turn to check that bad government action that overreaches and infringes on environmental rights.
Okay, but last November 2nd, through the work of Katie Koo and others, New York State has Article 1, Section 19 of the New York State Constitution, Bill of Rights, that says each person shall have the right to clean air, clean water, and a healthful environment. Wow. So do we have it now in New York?
Well, we have the opportunity to get it, right? So right now there are 3 states that have what I call a green amendment. So there's now New York State, there's Pennsylvania, and there's Montana. There are other states that talk about the environment, even environmental rights within their constitutions, but they don't raise up environmental rights, so they're given the same highest constitutional recognition, protection, and standing as the other fundamental rights we hold dear. But still, in New York and Pennsylvania and Montana, we still see that there is pollution and degradation that's taking place. And that's because it takes time to take advantage of a new constitutional amendment, right? When an environmental rights amendment, a green amendment, a green amendment is a form of environmental rights amendment. Not every environmental rights amendment is a green amendment. But when we passed New York's amendment, when we breathed life into Pennsylvania's amendment, when Montana's amendment was passed, you didn't have poof, like everything goes away, everything bad stops. Yeah. What we did was we created the opportunity for people to fight for their rights, hold government accountable, and to, over time, set the powerful precedent that will increasingly ensure that we do truly have a constitutional right to a clean, safe, and healthy environment. So there's work that we have to do, but the opportunity is now there.
So how are you going to infiltrate this opportunity into the other 50 states?
So we're going to do it by spreading the Green Amendment message, right? All of us are going to do that, just as we're doing around the world with the
with this message right here.
So yes, everybody's going to read the book and it will instantly happen. The way we get green amendments passed in every state in our nation, and then ultimately at the federal level, because we need it at both the state level and the federal level, is by helping people to understand that they don't actually have a right to a clean, safe, and healthy environment. Right now, most people believe that it is actually illegal to pollute and degrade the environment, that it's illegal to fill in wetlands and to decimate species, to sacrifice communities to pollution and degradation. They think that the law is in fact there to prevent all of those harms. What they don't understand is actually what I just talked about, is how the law is designed to work, is to allow pollution and degradation to advance, but in a managed way. And over time, as industry has gotten more and more power in the state capitals, the laws that we have on the books actually have, in my opinion, gotten weaker and weaker. And that's why the need for a green amendment has become more and more important. So the way we make it happen is we go out and we let the people know that they don't have a right to a clean, safe, and healthy environment. They have a right to free speech and freedom of religion. They have a right to bear arms. They have a private property. They have all kinds of rights, but they don't have environmental rights. And then we let them see the pathway to change that. And that pathway is by getting organized and getting active and speaking up and seeking and securing the passage of the Green Amendment in their state. So it happens through the people, by the people, because the constitutions ultimately, right, they're the people's documents. And so it's up to the people to fix them.
So we have in our Constitution something called the Due Process Clause. Everyone has a right not to have their liberty or their freedom or their lives taken or their property, I suppose, without due process of law. What does the Green Amendment add to due process of law?
Well, it makes the right to a clean, safe, and healthy environment, it raises up to that highest level, so that it takes that inalienable right and actually makes it enforceable in its own right. It's not just about due process before you can take it and decimate it. It's that you have this right, and when government officials behave in a way, through due process or not, that overreaches and infringes on these rights, now the people can turn to the Constitution and take meaningful action to turn back that bad government decision. So it is about more than process. It is about the substantive, fundamental, meaningful right to have pure water, clean air, a stable climate, and healthy environments, and to push back when government uses their process and their words and their actions all in a way that's designed to make pollution and degradation acceptable, and an entitlement of industry to the detriment of the people.
So let's take a practical application of this. The Delaware Riverkeeper, you were courageous and strong in the defense of the Delaware. And you had slap suits and attacks back on you, and you didn't flinch. You carried on. You were brilliant. But we've got a law in half the states, which we also have in New York State, for environmental impact assessment, the State Environmental Quality Act in New York. California has a strong one too. What's the Green Amendment, now that we have it in New York, what's that going to mean in terms of the right of the public to participate in evaluating an act that could have adverse effects on the environment procedurally, and what's it going to mean substantively when people are going to put conditions on some action?
So a Green Amendment does have those two parts, which you alluded to. So there is the procedural part. And whether you're in a state that has a strong law about review of pollution and degradation or review of government action before it's allowed to be put in place, or in a state that doesn't have that, a Green Amendment really does, by its placement in the Bill of Rights and by the choice of language, it really does require that government officials meaningfully consider the ramifications of the decisions that they're about to make and the actions they're about to take before they take them. They have to look at existing conditions. They have to look at cumulative impacts. They have to look at the ramifications of the new industrial operation before they permit it and allow it to go into place. So they have to do that work. And if they don't do that work, what we have demonstrated in Pennsylvania and Montana is the failure to do the work is actually a constitutional violation, because people do have this fundamental right to a clean, safe, and healthy environment. And before government officials can constitutionally, legally subvert it, they have to be able to demonstrate that there is a reason to do that, that there's a compelling state interest, and that they've done everything they can to minimize the harm, right? Because you can infringe even on fundamental constitutional rights. You just have to meet these additional criteria. So anyway, so part of it is you have to do the work. Now, in states like New York State and California, where that procedural component is already largely embedded in state law, that actually helps government officials in these states because they're already doing that work. And so if there is a constitutional challenge to something that they're doing or something that they've done, they will actually, or should actually, be able to point to the fact that they've engaged in that procedural analysis essential to ensure that they're not overstepping and infringing on environmental rights. So you have that piece of it, but you also have the substantive piece of it. There is a right of the people to pure water, clean air, a stable climate, and healthy environments. And there is a line that gets crossed. Where that line is, we are all going to have to determine together over time through advocacy and litigation. But there is that substantive piece when you can show that the amount of pollution and degradation, regardless of the process that took place, rises to the level of substantively, meaningfully taking from people their constitutional right to a clean, safe, and healthy environment. You can also use that to challenge that bad decision regardless of the process. And then there is this sort of other piece in the middle that I'm going to highlight because I think it makes sense here, but that sometimes there's a gap in the law. There are lots of things that happen in terms of government action and the environment where there is an absence of law. If we think about per and polyfluoroalkyl chemicals, PFAS, that man-made family of toxic chemicals in stain-resistant clothing and carpeting, on Teflon, the slippery popcorn bags, right? One of the reasons PFAS has been allowed to proliferate into the environment with such devastating consequences is because there were no laws to stop it. One of the reasons why fracking has been allowed to proliferate with such devastating consequences is because there are a lot of loopholes that let them off the hook in terms of environmental protections. So in those situations, you don't really have any process and you don't really have any substance in law to measure things by because there is this gap, there is this absence. But if you have a constitutional right to a clean, safe, and healthy environment in those places and those spaces, you can turn to the Constitution to seek and secure the procedural component, that thoughtful decision-making element of decision-making, and also to challenge substantively when you believe that the government action or failure to act has allowed so much pollution and degradation that it's devastating people's lives to what we can demonstrate is an unconstitutional level. And again, where is that line? We're all going to determine that together over time. That's part of the work that we, the people, have to do with our government officials.
So those are good examples where we have the environmentalists activating to protect the environment. what about the rest of the world that doesn't think as environmentalists yet? Let's take the human rights commissions and the human rights councils that exist, both here in the city and throughout the state of New York, for instance, and in other states. Last July, the United Nations General Assembly recognized the human right to the environment as a human right. It completely changed the dynamic of is it or is it not part of the Universal Declaration of Human Rights, and why don't we mention the environment? The UN has said all human rights depend on the right to life and the right to the environment as a ground floor, as a foundation for the whole field of human rights. But no Human Rights Commission or Council has thought that way yet. How can we take the Green Amendment and the universal human right to the environment into the world of human rights, which so far has been a little resistant? They have said there's a human right to water, but it's been a little resistant to jump into things like the dedication of your book, Nature.
So first and foremost, taking this message into the international arena, that's your job. And that's the job.
No, but I
of all the auspicious
I
people.
framed this as New York Human Rights Commission.
Okay, but to the extent that you're talking about, I'm just saying, right, that my area of expertise is the United States, and I own that and recognize that, and I will not try to overreach into your place in your space. But that being said, I think about your question or this conversation a little bit differently. I mean, whether or not people want to recognize it, any people, that in fact we the people do have an inalienable, inherent, indefeasible right to pure water, clean air, a stable climate, and healthy environment by virtue of the fact that we are people here on this earth. We do have that. That is our human right. And what I say to audiences all the time when I go to talk about the issue of green amendments is we actually, environmentalists or not, hear all the time in one place, space or another, you have a right to clean water. You have a right to clean, you have this right. And what I actually say to my audiences is, no, you don't. You don't. You have the inalienable right. You have the right in your heart. You have the right in your mind. There should be that right. But here in the United States of America, if you can't enforce a right, it's not really yours. You don't really own it. We have a right to free speech. When it's infringed upon, we can take action to enforce it and stop that infringement. When it comes to the environment, it's not the same. You have overreach, you have infringement, you have sacrifice zones, and we the people can do nothing about it because we do have the right in our heart and in our minds, but we don't have the right in the Constitution. And so it's a little bit of semantics, right? It might be your belief system, but if you can't actually enforce it in a court of law, I don't think that it is truly a right. And that's what a Green Amendment changes. It changes that inalienable human right into a constitutional enforceable right that we can hold government to account to protect.
So if a Human Rights Council exists in a local government, like we have in Westchester County, for instance, can't we go to the Human Rights Council and say, you have an obligation to hear my complaint about the denial of my right to the environment?
So again, the Human Rights Council, I'm going to be very honest. This is your arena. I'm thinking about local government officials. I'm thinking about state government. I'm thinking about state legislators. I'm thinking about the actions in their
These are local government organizations, Human Rights Council.
So to the extent that they are entities that are rendering decisions, that are giving people official permission or taking official government action that is resulting in actions or activities that are impacting the environment, then yes, they are obligated to recognize and protect the rights in Article 1, Section 19 of the New York Constitution.
So let's look at what is in that. All of these rights to life, it's not just life on the day of your deathbed. It's healthy life. You have to have a healthy existence. You have to be free of pollutants that are going to damage your health. So if that is part of the component, what about something else that goes into health? What about human dignity? Is that part of this amendment?
The way the Green Amendments are being framed, the way that the language that I am advancing, we are not using dignity language overall, although in the state of Maryland, that language is being included, right? So So every single state is different. They have a different personality. They have different leaders. They have different grassroots organizers. The state itself has a different personality. And that personality and the goals of those leading voices have to be incorporated into the Green Amendment language in order for them to own it, so that they actually do the work to get it passed. And so when I go into any state and start to work with a community, I talk about the criteria that are essential for a constitutional Green Amendment. It has to be in the Bill of Rights section. It has to be self-executing. It has to apply to all government officials at every level of government. And so there are some criteria that are must-haves, and I think there are other criteria that are really essential. It should be generational. It should have trustee language, because these bring other powerful attributes and benefits. And I even give model language. This is what I suggest based on what we have in Pennsylvania and Montana and now New York. But beyond that, it's sort of open for discussion. And in every state, the Green Amendment language has advanced differently. And actually, in the state of Maryland, there is one Professor May who has been very engaged in the Maryland effort. And that dignity language, because it is more in international law than in US law, and he works in the international arena, he has recommended that dignity language be added to the Maryland proposed amendment. So it's in there.
Well, what about our sister state in between Maryland and New York is New Jersey?
Yes.
And you have prioritized New Jersey, and it's just across the Hudson River, and all of us love New Jersey. So what's the New Jersey approach to the Green Amendment?
So New Jersey has all of the best attributes. It has individual rights. It has trustee language.
Proposal.
The proposal.
Right.
It has generational language. It's got all of the best components. And in fact, since the New Jersey Amendment was first proposed, I've learned a lot in my own Green Amendment journey. And actually, we're talking about making amendments to their proposal. But the New Jersey Green Amendment proposal actually preceded the New York proposal, which is interesting. But New York secured theirs first. It's also interesting. Yay! And one of the reasons why is because there are a few key people in key positions of power that have prevented the hearings at the legislative level necessary for the Green Amendment to advance and to be able to ultimately go to the people. So we're struggling in New Jersey with that reality, with the reality of the political system. But the people are getting more and more engaged. We have more and more legislators coming on board. The fight is getting stronger and stronger. And in fact, at this point, half of New Jersey's legislators are co-sponsors of the New Jersey Green Amendment. So I'm very, very confident that we will get there. And when we get there, we will have some really powerful attributes in the New Jersey language that doesn't exist in the language of some of the other states.
Well, let's look at a hypothetical. The Delaware River is partially up in New York State, and we have the right so that if you're a person living in the upper reaches of the Delaware, you have the right to the environment. What will adoption in the other half of the Delaware do if Jersey adopts it? How are we going to use that and make it operational, I guess is what I'm asking.
Well, in New Jersey,
or both. I mean, we already got it in New York. How can we use it in the upper reaches of the Delaware? And how can it be something that the entire Delaware watershed embraces as a floor for protection?
So in the Delaware River watershed, right, we now have New York's amendment and we have Pennsylvania's amendment. And Pennsylvania's amendment is actually, I would suggest to you, is the most powerful language right now nationwide. It's behind the 8 ball because we have to do the work, right? And we're doing that work, but we're getting really powerful decisions out of Pennsylvania. So half the watershed has the Green Amendment, and New York and Pennsylvania are helping to inspire the other watershed states, New Jersey and Delaware, to follow suit. And in fact, we have very strong proposals, as I said, in New Jersey and also in Delaware. And I am confident that we will get there. And what it will mean, I mean, right now, what it means is that when New York and Pennsylvania are undertaking their actions and activities at the government level, they have to respect and honor the rights of the people to a clean, safe, and healthy environment. Of course, we need that additional protection in New Jersey and Delaware. When we get there, when those government entities are making their decisions, we will have a higher bar there too. And so we'll be sort of lifting up the river. But we have to recognize state amendments apply within the states where they're operational. It is one reason why, and it doesn't apply to the federal government. It's one reason why we need a federal amendment as well.
So as we inch toward that, we've got the Delaware Commission. Could this amendment in New York mean that the New York representative or the Pennsylvania representative cannot act in a way that's inconsistent with the Green Amendment?
That is what we believe at the Delaware Riverkeeper Network, that yes, that at the Delaware River Basin Commission, right? This is made as the result of a state and federal compact.
Yeah.
And there are 5 commissioners. It operates on a watershed basis. It protects water quality and water quantity. And the commissioners are the 4 governors of the watershed states, New York, New Jersey, Pennsylvania, and Delaware, and a representative for the federal government. And at the Delaware Riverkeeper Network, we 100% believe that the Pennsylvania and the New York commissioner must comply with their constitutional obligations when they engage in their DRBC decision-making.
So the magic I see happening here is that now through states adopting the Green Amendment, we are basically taking a watershed, an interstate watershed that happens to have a compact, and breathing into it a high obligation to protect not just the water, but the environment as a whole that's related to that hydrological water basin.
Yeah, as we get more constitutional amendments passed in the basin, yes, we will absolutely be raising that bar. The interesting thing about the DRBC, the way decision-making happens is it's by majority vote, right? Majority vote rules. So we have 2 states with green amendments right now. If we could get a 3rd, well, that really helps.
So we'll be writing to the governor after the governor is elected in a few weeks, explaining that they have to instruct their representative to vote green. This is going to be a lively debate, when it gets going. Well, it was one of my great privileges to have many discussions with you as a student and to work with you when you were at Pace Law School. What would you say to students today from looking back that should inspire them to move forward into this world of environmental rights?
I think I sort of have 2 pieces of guidance for students, whether they're law students or not, young people, is pursue your passion. If you want to fight for the earth, figure out the thing that interests you. For me, it was the law. For other people, it might be mathematics or writing or research or social media or anything, right? Find that thing that you love, study it, and get really, really good at it, and then put it to work in the environmental arena. Because in the environmental arena, in environmental rights work, there is a place and a space for every talent. We need everybody. So do that. And by pursuing your passion, you will be really good at it because you're going to enjoy it. And so you will be better at your environmental rights work. That's number 1. And number 2, don't sell out. If you can't get a job that's fighting for the earth and fighting for what's right, don't sell out. Don't go work for the other side. Don't give yourself the excuse that I'm going to go get that job and I'm going to make that money until I pay off my school loans, and then I'll go do what's right for the environment. Because during the time when you were making that money to try to pay off your loans, people were dying. Forests were being cut. Ecosystems were being polluted beyond repair. Species were being brought to the brink of or over extinction, right? Kids were getting cancer. I mean, horrifying things were happening, and you will never be able to you'll never be able to remove the black stain from your soul that happened because you sold out. For me, I had my backup plan. If I wasn't able to get a job to fight for the earth, I have no idea why this was my backup plan. My backup plan, I swear to God, I still remember my backup plan was that I was going to go sell shoes, because I could go and make some money during the day, doing something kind of mindless. And then in the evening and on the weekends in my free time, then I could volunteer, right, and fight for the earth. So have like a backup plan that doesn't require you to sell out.
Oh, that's a great advice. One of the interesting things about our age today is it's in front page of every New York Times. The Guardian today said or UN says we're failing to attain our mitigation of greenhouse gases. Everyone is worried about climate change and the impacts of climate change. So they don't think Green Amendment, they think climate disaster. So how can we use the Green Amendment to give hope to the people who are angst about climate change?
So they're right, of course, to be anxious about the climate crisis and about the desecration of all aspects of our environment. I mean, it's all devastating. We need to work on it all. We can't just work on climate and ignore everything else. I believe we have to work on it all. And it's all, of course, interconnected. When we protect the air, we address the climate, right? So it all comes together. But I believe that constitutional green amendments can and should be pursued in a way that's complementary to every other environmental battle that's happening, including a climate crisis. We can't divert everybody's time, attention, and energy from dealing with the climate crisis or plastic pollution or the decimation of a species and say, okay, let's everybody go all in just on this green amendment and forget all that other really important work that's happening until we get this constitutional right and we can use it to go back and address that work. We have to do it at the same time. And so we have to make sure that we pursue our Green Amendment work in a way that is complementary to the powerful and important work that activists are doing. That's number one, right? We want to make it all complementary. And because I've gone into a state where there was interest in pursuing a Green Amendment, and somebody came back to me and said, somebody that was very much in there, and said, if we've done a lot of work to bring environmentalists together around a certain agenda. If you bring this Green Amendment idea, as great as it is, into this state, you're going to derail all that work. Please don't. Now's not the time. And I said, okay, and backed out because it wasn't going to be complementary. But in New Mexico and in Hawaii and in Maine and in New York and New Jersey, we advanced our Green Amendment messaging in a way that was complementary to and empowering to all of the other battles. When we do our Green Amendment trainings, we also talk about all these other issues, how they support Green Amendment advocacy and how Green Amendment success and advocacy supports them. So that's really powerful and important. When we get a constitutional right to a clean, safe, and healthy environment, of course, though, we will be bringing to bear the strongest, most powerful legal tool we have to address every aspect of environmental protection, including the climate crisis. So there is value in pursuing it and driving that forward, because when we achieve that goal, it will provide powerful, powerful protection. And the only other thing, because I see you touching the one, the only other thing is I think that the conversation we have about the environment and environmental rights and how empowering it is to people emotionally and intellectually, activists, right, and advocates, to know that they do truly have a right to a clean, safe, and healthy environment, and that they shouldn't be embarrassed by standing up and fighting against that project in their backyard when somebody gets up and says, oh, well, you're just the NIMBY, you're just a tree hugger. Right now, people are embarrassed when the opposition gets up and calls them names like that. But when we talk to them about the fact that they are in fact entitled to a clean, safe, and healthy environment, regardless of what the Constitution says, regardless of what government official says, regardless of what the industry says, right? It changes the way they think about and embrace this idea that they truly as people have a right to these things. And it becomes much more empowering for them as advocates and activists. And when they engage in their advocacy and their activism around the Green Amendment or any other element of environmental protection, they do so more forcefully, more powerfully, and absolutely more unapologetically, because they know that they are entitled. So I think it's very, very empowering all the way around. And those who are fighting, on the front lines of the climate crisis, this is only value added to that battle.
And this book makes the case that Maya has so eloquently articulated and so forcefully put forward today. So I think if we can get this book widely disseminated, get it into the hands of our students and students of all institutions and civic groups, this is the sort of thing, frankly, that the League of Women Voters, not just the League of Conservation Voters, but every civic group should think that this is a part of the inalienable rights that they are here to defend in our democracy. It's been a great privilege to be here for the launch of this edition of the Green Amendment. The organization, as you know, is Green Amendments for the Generations. So as she said, this is truly an intergenerational exercise, a campaign, spirited engagement or fight, depending upon how you want to call it. But we're grateful to you, Maya, for taking the leadership you have, for using all those dull days in law school to a good purpose in life and moving our entire agenda forward. So a round of applause to Maya van Rossum and congratulations. And although she has writer's cramp, she'll endorse a few or inscribe a few more copies of the book if you want.
As I say, and I've said it already once tonight, if you can read the signature or the message, it means that I didn't write it. So go away and be proud of your inability to read my message.
So we have a chance for a few questions. We have a roving microphone. I've posed some difficult questions and Maya's fielded them well, but who would like to pose a question to Maya? Here's a mic.
Or to Nick.
Well, or if she wants, you can put me on the hot
Right,
seat.
right, you've been doing environmental rights work longer than I.
Oh, we're all in the same boat together. Professor May.
Professor May.
Well, good evening. Thank you. That was fantastic. It's so inspirational. My heart is just racing. I want to go out and sue somebody. So a couple of things. One, on that notion, my response to the Professor Robinson's question about next generations and inspiring students, how to make it pay. Yeah, going to the other side, it has, there are certainly drawbacks to that. And for people who are interested in public interest litigation, but it's hard to make a living enforcing constitutional provisions that don't have mechanisms for recovering attorney fees. So I'm just wondering what your thoughts are about that. Secondly, now for something completely different, is about indigenous constitutions. There are more than 200 indigenous constitutions in the United States alone. So I'm wondering what your efforts can do to provide for the greening of those constitutions. Thank you so much.
So it's interesting you bring up this question or this point about attorney's fees. So because we've been having this conversation exactly in New Mexico. Last year in New Mexico, last year was the second year, this will be the third year when they were advancing their proposed Green Amendment. And at the same time, there was a proposal for a Civil Rights Act to be passed that would allow money damages for any victories advancing constitutional fundamental rights, right, legally. And so that actually ended up derailing the Green Amendment because the concern was that the Green Amendment now would become, if added to the Constitution, would now become enforceable through the payment of money damages rather than equitable relief and sort of fixing the constitutional problem. So there were fears that there'd be all these lawsuits for everybody to get all this money around environmental, constitutional environmental rights violations. So this go around, and truthfully, it is my belief that Green Amendments are much more powerful when we in fact are clear, either by the judicial decisions and the precedent in that state or by language, which I'm about to tell you about. Green Amendments are much more powerful when we are clear. The relief is equitable relief. You cannot get out from under a constitutional violation with regards to environmental rights by giving a payout to the plaintiff. It has to be about fixing the problem for the whole community. So it has to be about equitable relief. So what we did in New Mexico was there is actually language, and there was a lot of debate, but there's actually language to say that the relief cannot be money damages. But it does not say that it cannot include recovery of attorney's fees, which is another one of the elements of the Civil Rights Act that got passed in New Mexico. It said that for a legal challenge of a fundamental right, if you're victorious, you can get money damages and attorney's fees. So in New Mexico, arguably, this is the intent, you could actually get attorney's fees for bringing a constitutional challenge. And I think that that's value added because it is very, very costly to pursue legal action, let alone constitutional legal action. And mostly communities are left to good environmental law clinics like PACE has, right? Like Widener has, to get that work done for them. But if there were the ability to recover attorney's fees, then we would make those lawsuits and those lawyers much more accessible. So that's just a little bit about how it's actually playing out in reality. Do with it what you want. In terms of Native American communities, in Maine, in New Mexico particularly, and in Washington state, where there are very vibrant Native American communities that are a very big proportion of the state, there's a lot of conversation. First off, we are very careful to engage in consultation to make sure that early on, they know about the Green Amendment, they know that it cannot be enforced against them, right, because they are sovereign, but that they can use it to protect themselves from bad state action that might result in a constitutional infringement of their environmental rights. But there is conversation, there has been encouragement from some of our legislative champions to say, if you want to add this concept to your own tribal constitutions or governing documents, that would be a good thing, right? So, I mean, I don't actually take a stance on that, but that is something that is being encouraged by some of our activist leaders and legislative leaders in those states.
Although I think in the indigenous communities, they're going to say our respect for all our relatives, all living things, is already a part of our value system. We don't need some little language put in a constitution that the federal government requires us to adopt to have federal recognition. We were here before the federal government. So I think we have to be sensitive to the fact that the value systems of most indigenous peoples in North America and perhaps around the world already embrace this and they act on it. We're the ones that don't act on it and have forgotten about it. And the only reason they have constitutions, written ones, is that the Interior Department requires it, basically, in Congress. It's not necessary for their community to exist as a people. But other questions or comments that people have? Yeah.
Thank you for talk, learning a lot tonight. New Jersey is a special place in my heart, so I'd be interested to hear your thoughts on how a Green Amendment in New Jersey might interplay with the existing environmental justice legislation and forthcoming regulations.
So in any state, all a Green Amendment can do is really help strengthen existing law, because now all laws already on the books have to be interpreted through the lens of protecting the constitutional right to a clean, safe, and healthy environment. Right now, laws get interpreted sometimes robustly and vibrantly, depending on who's in charge in that state, and sometimes they get interpreted weakly or they're not enforced. So having a constitutional Green Amendment will just strengthen every legal protection in New Jersey for the environment as in any other state, because of that shift in interpretation and application and the duty of government officials to utilize those laws in a way that helps to advance environmental rights.
Yeah. Professor Gaillard.
Nice to meet you, Emily Gaillard. I have two questions. First of all, it's about the application of the Green Amendment in Hawaii. There is an island where all the multinational, such as DuPont de Nemours, Bayer, etc., Monsanto, are testing without any control many cocktails, all the pesticides before they have been authorized to be entered into the market. So this is a school case of huge violation and transgenerational violation of rights and of nature's rights. And there are many birth defects over there. And the second question is, I was wondering if there would be a kind of extraterritoriality, I would say that in French, for companies based on these states, for instance, for multinationals in New York, would they have extraterritoriality obligations or not? Thank you.
So could you all hear if there's a gap in the law and the pesticides are being used in such a way that we're being poisoned? Does the Green Amendment give us a opportunity to address that phenomenon? And in any event, if a company is doing it abroad, and can we use our right to have extraterritorial or application of this right to conduct outside the state of New York, for instance, because it's having an impact in the state of New York?
So, so two great questions. So I would hope that in the pesticide context, just based on what you've just said, that yes, that the Green Amendment could be a really powerful, helpful tool, and could help. Oh. And could be a really powerful complement to the existing constitutional language. But adding that individual right of the people to a healthy environment, it would be very powerful value added in that context where you have toxins and chemicals being used in a way that really is invading people's bodies and causing serious harm. So I would think that, yes, it would be tremendous value added. In terms of your other question, I would probably need to know a little bit more. The truth is, right, the constitutional obligation applies to the government officials. So we would have to be finding that state government action that is resulting in the harm that you're talking about. Was it a permit that was issued? Was there a law that was advancing it? Was something happening? You're talking about extraterritorial, but just thinking about PFAS, is there something happening within the state where the government is failing to act? And as a result of that failure to act in that state, we have a proliferation of a problem. And then we use the constitutional right and obligation to address that government action or inaction resulting in the harm. So I think I probably, in terms of the multinational question, I would be saying, what is the state action, assuming we have a Green Amendment in that state, what is the state action that we would be challenging constitutionally? But it also becomes another reason to have a federal Green Amendment, because there may be federal action, right? So we, here in the US, right, the states have a lot of power when it comes to the environment, and the federal government has a lot of power when it comes to the environment. So we really need Green Amendments at both levels to be able to have that blanketed protection that's so essential. That might be helpful in the kind of context you're talking about, but I'm afraid I don't know quite enough to be able to fully answer the question. Maybe you do.
Well, I was trying, as you were speaking, I was trying to imagine a circumstance in which New York would have authorized a manufacturer from abroad to sell its product in New York or license it for sale in New York. And in any event, we collect the taxes on what they do sell in New York. So there's probably going to be an angle where you could take on a pesticide application and find a way, if it's poisoning you, to take some action. But by that time, it's already happening in the state. So it's not extraterritoriality as such. Now, there have been a number of claims on climate change that the emission of greenhouse gases in some part of the world is then harming people in another part of the world through the effects. So I can see that as a possible place in which but the question again is, as Maya says, is what is the New York state government action which violates the New York Bill of Rights for that to happen? We have to find that action in the state. So
the other thing that's really, really important as we get these amendments passed and we start to use them is we really have to be careful not to overreach. And, right, they say good facts make good law, bad facts make bad law. And so if we have, as these Green Amendments start passing, people just trying to challenge, every piece of trash on the ground based on, and I'm not saying that's what anybody here was suggesting, I'm just thinking about this idea of precedent is so important, then what we're doing is devaluing, first off, the importance of this constitutional right, but we're also handing an opportunity to justices who don't agree with us to do an interpretation that weakens the amendment. Now, because the amendment is explicit and clear, they should not be able to strip it away from you, but they could interpret it in a way that is weaker and weaker and weaker. Now, that being said, if you get and read the book, one of the key stories, right? One of the key lessons, and it's why I emphasize this, is that is actually what happened in Pennsylvania. Pennsylvania's Green Amendment was passed in 1971. And almost immediately, there was a legal challenge advanced that really had no business using the Green Amendment as a fundamental core of the challenge. It was against an educational viewing tower on private property that was looking out over a historic battlefield. And what happened was, I can only imagine, I can't honestly say, but when this case was brought based on constitutional grounds, the justices sitting on the court said, holy crow, if this is how people are going to use this constitutional right to pure water, clean air, and a healthy environment, we're going to put a stop to it before it even starts. And they actually declared the right to be the environmental, the constitutional provision to be just a statement of policy. As the Chief Justice said at the time in the dissent, he described the decision as disemboweling Article 1, Section 27 of the Pennsylvania Constitution, robbing it of all of its legal life. And so for 42 years, we literally had really powerful language in the Constitution, but nothing changed because the amendment was declared to be just a statement of policy. Fast forward to 2012, when the Pennsylvania legislature passed an excruciatingly pro-fracking law that was going to allow fracking that was already happening in the state to get exponentially worse. My Delaware Riverkeeper Network organization teamed up with 7 towns, was represented by 3 super smart attorneys. And we thought, you know what? This might be such an egregious overreach by the government officials in the fracking context that maybe we have those great facts that could overturn that 42 years of bad precedent. And that's exactly what we did. And so the good facts overturned the bad precedent, and we breathed legal life into Pennsylvania's long ignored Green Amendment. But, you know, we could have had 42 years of progress, but for that major setback. So we have to be careful. Again, as Green Amendments are passed, let's use them wisely to build the, put together the building blocks of stronger and stronger precedent over time. So we are building a wall of defense for our communities, for our natural resources, for our environment, and for future generations based on the right.
Well, I think we have come to time, and we're certainly well aware of how you succeeded in cajoling the courts in Pennsylvania to courage, and now we need to do the same thing in New York. And Professor Gaillard, I should say, another orb weaver in our midst, one of the world's leading experts on intergenerational environmental rights. You've given me a very mischievous thought, which is to think about New York State does, in fact, give corporate charters to corporations. And so perhaps if you have a particularly bad actor, you can suggest it should be withdrawn because it violates the environmental right. I'd like to thank everyone for coming, and especially thank you, Maya, for being here and sharing your book with us. And thank you, Nick, for a wonderful conversation. Maya, she does have piles of these wonderful books in the back, and she is willing to give her personal signature, which you will know is real because you won't be able to read it, and you can interpret it as you see fit. So please join me in thanking our speakers.